Attorneys in the Diddy sex trafficking trial spent day 30 arguing over the specific charges the jury will consider. The jury will use these verdict forms to decide whether Sean Combs is guilty or not guilty. Here are the highlights.
Anything else on the sex trafficking instruction from the government? Maybe that's a better way to go about it.
Just on the unanimity instruction, I don't know if the defense has anything before then.
Oh, we do.
Okay.
So, the first one, and this is, I think, extremely important, is on page 43, lines 22 to 24. The court has added, at the government's request, an instruction that it's not required that the victim ever actually performed a commercial sex act. And in the specific context of this case and the way it's been charged, the way it's been litigated, and the way it's been tried, that cannot be included. This case was charged, in the indictment the allegations are, in counts 2 and 4, as well as paragraph 17, as well as 17 and 19, as well as the RICO speaking language, 12A, B, D, and E, among others. But I'd like to just focus on the charges. Both 2 and 4, respectively, in the to-wit clause allege that the purpose, that Combs recruited, enticed, etc., and willfully caused victim 1, and in count 4, it's victim 2, now Jane, to engage in commercial sex acts knowing and in reckless disregard of the fact that victim 1 was engaging in commercial sex acts as a result of force, fraud, and coercion. And it's those specific charges and allegations that allowed the government to assert that conviction on either of these counts would result in a 15-year mandatory minimum sentence, which the government also used to detain Mr. Combs, etc., and the statute, in the provision that talks about the mandatory minimum, 1591B, specifically says that the mandatory minimum applies if the offense was effected by means of force, threats of force, fraud, or coercion. What I'm arguing is that including this here and allowing the government to argue, as they've indicated they may, for instance, I can't remember where it was alluded to, but there was discussion recently that they may just argue that it's enough that Mr. Combs, for instance, rented a house for Jane even if she never committed a commercial sex act, or similarly provided financial support to Ms. Ventura.
We are certainly, as the court said, going to argue that there were completed commercial sex acts in this case, but there may be particular dates on which those sex acts were not completed, or the jury may have a question. And that shouldn't bar us from being able to argue that that's still a violation of the statute. I don't think that the defense has a problem with that, given that they understand that this is a correct statement of the law. The Commercial Sex Act does not have to be completed.
And by the way, the government is going to, in fact, argue that the commercial sex acts did occur on those dates, right? And that is going to be the government's position, or are there going to be instances in which the government is going to say, no, commercial sex act occurred, and nevertheless, there is liability under this statute?
So, a few points, Your Honor. The majority of times, the Commercial Sex Act is completed, but there are times, for example, you may remember, where Jane testified where an escort was sent away by Mr. Combs, and so the sex act there wouldn't have been completed. In addition, at the end of the Intercontinental, Mr. Combs uses force against Ms. Ventura and attempts to drag her back to the room. But there's not another commercial sex act that is completed. However, he still has the required intent at that point. So there may be particular instances in which the Commercial Sex Act is not completed, which is why this accurate statement of the law needs to be provided to the jury during the jury instructions.
I'm going to, at this point, my intent is to overrule the objection and include that language, but I'm going to think about it, and I'll let you know. Any objection from the government on page 32?
Yes, Your Honor. So on page 32, at the end of the definition of labor and services here. So in line 3, the government would request that the court instruct that labor or services can include sexual services, and we noted this in our papers. But I think this is supported clearly by the R. Kelly decision, and it's a binding Second Circuit case law here. And I will say that the government is going to be arguing that certain sex acts are labor at closing argument, including freak-offs, including hotel nights for Jane and Cassie, and including sexual assaults for Mia. And it may not be something that the jury understands, that sexual services or sexual labor can fall within the statute. And I will note that even Sand itself recognized that the labor and services definition could be expanded where cases depart from the ordinary. And I know the defense has already talked about it in its Rule 29 argument, how this is not the kind of case that the statute was originally targeted to criminalize. Instead, it was targeted to criminalize slavery or involuntary servitude, and that there are different things about this case, including that the victims don't come from overseas or that the victims are well off. And so I do think that this is the kind of case where we need to make it clear to the jury that there is a different kind of labor that qualifies under labor and services. And Sand even itself points to United States versus Kaufman, which is a 10th Circuit case in which sexual activity is addressed and falls within the definition of labor and services. So that's the government's request.
I'm going to overrule the government's objection. I don't think there is a dispute that services of a sexual nature can, given the circumstances, count under the forced labor statute. And that's why the court did add the additional language the government proposed, that labor or services need not be paid for in the economic sense. That, coupled with the broad definition of labor and services, provides the foundation for the government to argue that the facts of this case would fit within the forced labor statute. Let's move to the Controlled Substances Racketeering Act. Any objections from the government?
So, on page 39, Your Honor, a few things. First, on line 7, there's an instruction that distribution does not require a sale. I think the government had asked for additional language in accordance with Second Circuit law that sharing drugs with friends is direct evidence of engaging in distribution, which I think will be relevant for this case. And it is consistent with United States versus Wallace, which is a Second Circuit 2008 case. So we would ask that Your Honor give that instruction.
Why isn't that captured by the existing language? Meaning that you can make that argument and it turns on the facts and circumstances, but this definition certainly provides the foundation for you to make that argument.
I do think the definition so far is helpful, but I think this really crystallizes the issue, and it's an accurate statement of the law, which is why we would ask that you give it to the jury.
It's too tailored to the facts of this case, Your Honor. This is what they can argue, but we can't have something in the jury instructions that basically makes the government's argument for them.
Yes, I agree with that. That's why I asked to understand what the addition was. I think that that's essentially another more argumentative way of saying what's reflected in the prior two sentences. So we will overrule the government's objection. Counts 2 and 4.
Yes, Your Honor. So as to sex trafficking, we have a similar objection as was raised to forced labor about the instruction related to physical restraint not being required. I assume Your Honor would make the same ruling here, but we would understand that the defense would not be making that argument, as was the same case for forced labor.
And the defense is not going to make that argument, that physical restraint is required for purposes of sex trafficking.
No, Your Honor.